A warm welcome from my end as well to everyone who is present. So I'm really glad to be here. So I've heard a lot about PLEA, and it is really nice that PLEA conducts such programs for bringing out legal awareness to people who are really keen on knowing the aspects of law. Law as an aspect is not only made for lawyers or judges or the police officers, but law is something that you know even a normal citizen of India or any citizen in any country of the world should always have an inclination to have the basic understanding of it, because after all, law is made for the people's survival and for the law and order and a better lifestyle. That is why every democracy or a republic or a state is known as a welfare state and not as a police state. So that is the whole idea, and this idea of a welfare state emerges from law that ensures that people's rights are preserved. So today's topic also that we'll be covering is has a lot to do with the personal liberty of the person. That is why it's like arrest, investigation, and inquiry. So the reason why I said that awareness that PLEA is bringing is very good. So I'm very happy that organization exists, which actually bring out the knowledge of law to everybody who is inclined to know about it. So now coming to the topic, so it's arrest, investigation, and inquiry. Now the most amusing part is, I was having this discussion also. When we talk about arrest, everybody understands what arrest is. Even the simplest of a man who may not know the language or even not acquainted with English will also understand the term arrest, because arrest is a very popular term. The most amusing part is all the laws that we have in our country is extremely detailed. Every provision, every aspect, every wordings used in the law is properly defined under law. But if you see the provision of arrest or the word arrest, the term arrest is nowhere defined under CRPC or any other law for the time being enforced. So that is the most amusing part, that arrest as a term has not been defined anywhere, but is the most frequently used term in any criminal proceeding, if you see, whether it's bail or an investigation by an officer or any other court proceedings in criminal law. Arrest is like, and even in civil law aspect as well, where arrest is concerned, arrest is a widely used term. Therefore, knowing about the basic terms of arrest is very, very important, because whenever a person is arrested, the liberty of the person is constrained. So liberty can only be constrained when there exists reasons for doing so. Because in a welfare state, like I said, everybody enjoys their rights. So if an arrest occurs, it has to be for reasons which is in the best interest of the collective of the nation, to prevent one individual from committing a crime or further crimes, or for other reasons. That person has to be detained in order to protect the welfare of everybody else. So that is the basic tenet why anybody would be arrested. Now, before going and focusing on the term of arrest, it is very important that from a legal terminology, the arrest is relevant for conducting an investigation. Now, the aspect of detention I will be coming to later, because both go hand in hand. Whereas arrest, if like I formally focus on that aspect, when chapter 5 of CRPC deals with arrest in a very detailed manner, it has the procedures, the rights of the victims or the accused who are arrested, and the reason and the tenure on the procedure of everything concerned with an arrest is described in detail in the chapter 5 of CRPC. So that would be the main focus of my lecture here on, that is the concept of arrest. Apart from this, there is aspect of a detention also, which is also a form of arrest, but is not covered under the aspect. It may not be necessarily for an investigation. So therefore, I will just touch upon the aspect of an investigation. An investigation is done by the law enforcement agencies whenever a crime is committed. Now, a crime, what we call as a general term, crime as such, is in the legal language known as a non-cognizable offense or a cognizable offense. The simple distinction of a non-cognizable or cognizable offense is, cognizable offense is a more serious kind of an offense, whereas non-cognizable is a less serious kind of an offense. To give a very easy example for people who are not familiar with the term, for example, I get slapped by a person. I am hurt, of course, and the person has used criminal force on me, but it is not as serious that I have, lost an aspect of my life or it has prevented my day-to-day life from happening. So I'm just hurt and a criminal force is applied. I go to the police station, I ask the police to register an FIR or arrest the person. The police will not do that. Why? Because it's not a serious offense. So police will register a non-cognizable offense report and give you a copy of the NC. Now the police have a jurisdiction here and a discretion here. They can seek the direction from the jurisdictional magistrate to conduct further inquiry into this incident, or they will ask you to proceed to the magistrate court directly and will ask you to file a private complaint based on this NC and initiate court proceedings directly through your lawyer. So ideally in an NC, hardly police, like very rarely, I've never come across this also, that the police investigated a non-cognizable offense. It is a very rare scenario to see. So police generally investigates a cognizable offense. Now, when it comes to a cognizable offense, like I said, if the same example where I told you if I get slapped, it is a non-cognizable offense. Let's say someone broke my hand. Now my hand is like shaking, bones are broken. It's a very serious offense. I can't conduct my day-to-day life. Everything has come to a standstill. I'm very grievously hurt. So I go to the police station. I ask them to register an FIR. Of course, they will have to register an FIR, and that will be under the provisions of grievous hurt, under the relevant provision of the Indian Penal Code. An FIR would be registered. Now, this is where the aspect of investigation starts. So if I take it from there, the moment an investigation commences is when the FIR is registered. The first information report is given by the complainant or the victim who has suffered the injury, or it can be reported to the police by anybody else. Imagine if I'm in a state of murder, I'm hospitalized. I may not be in a state to register an FIR. So my next of kin or my friend or anybody who has witnessed the crime directly happening that to me can go and report the same to the concerned police station or the nearby police station. So they will take down the statement of the person. That person will be the informant or the complainant who has informed the police about what the incident is about. And forthwith, the police are mandated to register an FIR, and a copy would be served to the person who is registering the FIR. A report would be sent to the magistrate, a copy of the FIR, and investigation commences from that moment itself. An investigating officer is allocated the particular case and he starts with the investigation. Now, this is the crucial aspect. I will touch upon the investigation aspect later. I gave this introduction about investigation and cognizable and non-cognizable offense to tell you all how does arrest come into effect? When does arrest arise? So here is when arrest arises. So the moment I say that, an offense has been committed against me and an FIR is registered and an investigation is started. Now, the major aspect that an investigating officer has to consider, now that is where I would recommend whoever is hearing me right now, if you all have a provision to just open a simultaneous window in your laptop and you do a simple Google search of criminal procedure code, you should get a PDF available, or if you have a Bear Act or any other reference book with you, then that also can be referred. Because if I refer a particular section, I will be trying to summarize that aspect for an easy understanding of all the viewers right now. But for your deeper understanding, when I'm touching upon that particular section, you can always read simultaneously with me. So you can either use a PDF version on whatever browser you're using, or you can refer to any reference book or a Bear Act. Anyway, so I'll continue. So this is where the aspect of the arrest arises. So the moment the investigation commences, the police officer is supposed to gather evidence. Now, the primary evidence and the most important aspect sometimes can be gathered from the person who has committed the crime. For example, let's take theft for an example. So I accuse that my mobile phone is stolen. I know that the person who has taken it, or I don't know who the person who has taken it. Now, the person who has taken has a possession of stolen property with that person, and he may actually try to create a third-party interest or sell it off or do something with that particular stolen property. So sometimes if the police officer feels that apprehension of that particular person is very much important for the investigation and recovery of the stolen property, he may forthwith find out the person accused and he may go and arrest that particular person. So that is where the aspect of arrest arises. That is for either questioning the accused who is there in custody, or for prevention of further crime, or for prevention of any other activity which is considered illegal as per our law. So arrest arises as a concept when a commission of offense has taken place and has been reported to the concerned police station, investigation has started, and as part of investigation, arrest happens. So arrest cannot happen without an FIR or an offense being registered. And if it's a non-cognizable offense, if suppose the police decides to investigate, takes a special provision from the magistrate, a permission from the magistrate to investigate, a warrant may be issued for the arrest of that particular person. Now, this is now the other important aspect is I will focus on the particular section, arrest of persons, section 41 of the CRPC. It's a detailed aspect when the police officer may arrest without a warrant. So 41 of CRPC, section 41 of CRPC gives a detailed highlight as to when the police officer can arrest without a warrant. simple aspect is when in the presence of the police officer someone commits a cognizable offense, or that, like I said, a report is given directly to the police officer of a commission of a cognizable offense. He or she has reasonable belief keep from the information disclosed to the police officer in writing or otherwise, or a suspicion exists, the police officer can arrest without a warrant. Now here is a very important aspect. Whenever you arrest, there is guidelines of the Supreme Court given in the case of a very landmark case. I think most of you all might have heard in Arnesh Kumar versus State of Bihar. So guidelines are given to ensure that there is no colorable use of power by the police authorities while arresting. So if you arrest someone, let's say, has committed a crime, I gave an example of theft or a stolen property, or how further crime could be committed or the stolen property interest could be created. Therefore, it is essential to arrest such a person. But sometimes it could be that it is not essential to arrest a person. For example, I'm accusing someone of a trespass or something. The person has completely withdrawn, and that it is not the police authorities has already questioned the person, has cooperated with the investigating agencies, and where arrest is not required, the Supreme Court has also set guidelines under Arnesh Kumar versus State of Bihar that such parties should not be arrested. Now, the same thing, the guidelines given by the Supreme Court in the case of Arnesh Kumar versus State of Bihar is in furtherance of what is given in the CRPC already. So, Section 41, I will just highlight the particular provision that if the offense is only till 7 years or up to below 7 years or up to 7 years, the police officer has to be satisfied that arrest is necessary to prevent such person from committing further crime, then for proper investigation of the offense, or to prevent such person from causing the evidence of the offense to be disappeared. A lot of tampering of evidence occurs, that the or as a witness could be intimidated. So sometimes a police officer prevents, even for a crime which is for 7 years, to prevent such things from happening. Like I said, illegalities, to prevent further illegalities from being committed by the particular person who is, the accused in a particular crime. So to prevent further illegalities, the person, like I highlighted from Section 41, the police officer can arrest. Now, the next aspect is that, when a serious offense is committed, like when above 7 years, if an offense is committed, there is ample discretion given to the police authority to arrest a particular person, because the offense may be of life imprisonment or death. So that means the person apprehended by the police has done something that is something very, very serious and detrimental to the interest of the society. Such a person being not under the custody of the police creates a clear hindrance to the public peace, and people may be afraid. So in an offense where the imprisonment is for death or life imprisonment, the police officer only needs to believe that this person has committed the particular offense alleged from the information disclosed to him, and he can forthwith arrest without any other further justification. He can take into custody the particular accused who has committed such a heinous and a serious crime is believed to be committed. Further, the other people who are supposed to be arrested, for example, like a proclaimed offender, or if a stolen property is obtained from such a person, and some other concerned aspect of people who can be arrested, are given in detail under Section 41. I will touch upon, if time permits, I will come back to this, that who are the people who can be arrested in further than that. But the basic understanding of everybody that should have is, if a cognizable offense is committed, there is chances that the police will arrest you, but it always does not mean that the police have to arrest you. If it's something that you're cooperating with, then, and if the offense is not a serious nature, the police officers, the Honorable Supreme Court and several high courts, I gave a reference of Arnesh Kumar versus State of Bihar. Apart from those, also in many several judgments, the high courts and the Supreme Court have very categorically stated that just because a power exists for the police to arrest does not mean that the police officer has to arrest. So this is one very important aspect that you all should be aware of. So if it's not a serious offense, the police officer ideally should not. So the next provision, that is 41A, discusses an aspect where the police officer does not arrest you, is he is duty bound to issue a notice under Section 41A of CRPC. Now, this notice is asking the particular person who is accused to come and cooperate with the investigation. He or she who is the accused will be called to the concerned police station on a particular date at a particular time for cooperating with the investigation and conducting the interrogation in the particular case. So as long as Section 41A of CRPC says, as long as the person cooperates, attends the police station, then the police officer is not supposed to arrest unless he believes that there exists some other reasons where the person has to be taken into custody. Mr. Harjinder Singh is asking a question. Yeah, sir, tell me.
My question is that can 41A of CRPC notice can be issued multiple times? or it is issued only once?
No. So, for example, sir, if you see the enforcement directorate in that Jacqueline Fernandez case, and so many cases, I think, comes nowadays. I'm reading a lot of news reports whenever it relates to some NDPS case or a drug-related case. Notice can be issued again. Summons can be issued again. For example, if for a valid reason it is communicated to the police authorities. For example, let's say Mr. Singh, right? So, Mr. Singh. So, let's say I have been issued a notice. I am accused of an offense. I'm under COVID restriction. So I can't come to the police station, of course, for a question. So there, I will try to reach out to the police mechanism using my next of kin or my friend or a representative or to a lawyer and inform the concerned police station that so and so is my difficulty. I would like to appear before you on the next convenient date for me or wherever is convenient for you. So ideally, they are supposed to issue a notice again for your appearance. So whenever the police authorities want to have a question for you on record, they should ideally send a 41A notice as many times as possible as they want to question you. Otherwise, tomorrow, if they don't send the notice, it could also be that because in one of the cases that I've dealt with, my clients who are accused in a particular offense, they were never called using a 41A notice. Only one notice is sent like a standard format just to show that they've complied with the law. And then later on, they call by generally just they call on the number and say, ki, kal aa jao, saab ne aapko bulaya. So this also happens. It is not always like a 41A notice is issued. The police, the CRPC or the concerned IO may just call you and say, "Ki kal aap police station aa jao, sabko aapse baat karne ka hai, investigation related." Mostly this is what happens. I'm telling you the reality of it. तो अगर आप आओगे तो you have a right to insist कि आप notice दे के बुलाओ मुझे, because sometimes it may happen कि you may go and attend the police station. This is what happened to my clients also. But later on the police said कि ये आए नहीं. So when you say I nahi, then you'll have to resort to other evidence like CCTV or some other person who has seen you go to the police station and then prove your case कि आप गए थे police station में investigation में cooperate करने के लिए. But अगर 41A notice है, so the police can, if it's a good officer conducting a good investigation, he will ensure that 41A notice is issued. Because अगर accused बोलता है कि मुझे कोई notice नहीं आया, मुझे नहीं बुलाया गया था, the police can show this notice as an evidence.
Thank you, sir. Thank you very much.
Always welcome.
My question is that when there is domestic violence and there are repeated offenses happening, although NC complaints are filed, but can a woman ask for police protection, without going to the magistrate? Or you require
the question is, police protection as such is always a discretionary measure. Now, there is an aspect, there's a witness protection scheme made by the Honorable Supreme Court to prevent witnesses. So, for example, Ms. Swati, this provision can be used sometimes to seek a provision. So, there is a district committee set up at every district where the public prosecutor of the district, the superintendent of the police, and some other member is there who will be a judge who will ensure that, if a protection to any citizen is necessary or no. Now, the reason why I said is that you asked me a question, without going to the magistrate, can protection be accorded? So generally the lethargic mentality of the police is that when someone comes and says कि मेरे ऊपर domestic violence हो रहा है, the police will not be keen to offer police protection to you. Already if you see the reality, if you go behind the reality also, the police force is heavily burdened. इतना बंदोबस्त होता है, the number of police personnel compared to the people in our country, the ratio if you see is very despair that way. So it becomes a pressure for the police also to protect every now and then, because if you go by a general mentality, domestic violence is a huge issue in our country. If every woman goes to the police station and says protection chahiye, it may become too unreasonable. Pura station police protection mein lagana padega. So therefore that witness protection scheme mein a committee is set up where before the committee you have to justify why you need that protection, or else you can go under the Domestic Violence Act, where the Domestic Violence Act, the concerned magistrate will grant you a protection order under the relevant provision of the DV Act. So that is the way you can easily get a protection order. Like as an interim measure also you may get a protection. If violation of the protection order will result in section 31 of the DV Act, where the police can arrest the person who is violating the protection order of the magistrate. So I'm proceeding with that. So we discussed 41A notice. 41 talks about how on what occasions the police officer can arrest without a warrant. 41A talks about how a police officer is supposed to issue a notice in case if the arrest is not happening, there is no need to arrest the particular person. Now, then 41B focuses on now 41B and 41C is morely about the control room and the procedure. So I'll come back to later, because section 41 to section 60A deals with all the provisions of arrest. So like I said, I will proceed with the aspects of who can make an arrest and on what reasons can the arrest be made, and then I will come to the safeguards of the person who's arrested. So I will skip 41B, 41C for now, and I will directly come to section 42 of CRPC. Now it says arrest on refusal to give name and residence. Now this is an aspect. It does not matter what kind of an offense. If of course it's a cognizable offense, the police will proceed as per section 41. But a non-cognizable offense, even if it is committed by someone and if the police officer wants your details and asks for your details. So this is very important. I think you all should remember. Like say you are walking in at night or some suspicious activity has taken place near you, and suddenly the police officer comes there, van comes there and starts inquiring everybody. So there could be a reason that the police officer may genuinely believe that you are involved in the particular act. So it's not necessary always to get into a quarrel with the concerned officer. If the concerned officer is asking your name and your residential address on suspicion of you being involved in a particular offense, out of nowhere someone comes and asks the details, it does not make sense. Of course, you can take you can make necessary complaints before the concerned police station that I was being harassed by. That's harassment. But what I'm talking about is a situation where in a suspicious circumstances or in an odd hour, you are caught somewhere and the police officer has reason to believe, and they approach you and ask you for your details, like your name and a residence address to call you for questioning or something. If you do not give your details, the police officer has authority to arrest you. Now, that particular reason for arresting is only to ascertain your address details or your name details. It can't be an indefinite arrest. That after the arrest, immediately the police officer is supposed to use all his powers to find out who you are, where do you stay, and the other reasons to ascertain your identity. That is the whole reason why under section 42 you could be arrested. And if suppose your details cannot be ascertained, you are supposed to, again, within 24 hours, the maximum time allotted to the police officer is to ascertain your details within 24 hours. If still the police officer is not able to ascertain your details, he is supposed to bring you to the jurisdictional magistrate for further detention for ascertaining the details. Then I will come to a very interesting part. Section 43, arrest by a private person. Of course, like it exists in other countries as well, and similarly here as well. It need not be that a police officer be at the right spot at the right time when a crime is committed. It can so happen that the crime is committed in front of any of us. If a crime is committed and if it's like serious of nature, if you are well within your power to be a good Samaritan and a good citizen and wants to ensure that no further commission of that person, further commission of any offense takes place by that person, or to detain such a person from escaping, you can use force to arrest that particular person. That is what section 43 talks about. I'll give you a very interesting example that which happened to me like around a few months back. I was assaulted and the investigation is still underway by the police. So it was an urgent scenario where I had to meet the client late night as he was apprehending an arrest or something. So I had to be there, and at night it was like around 2 a.m. and I was attacked by a person on a moving bike. So he sped past me and he just used his hand to very rashly hit at me, and then he just my specs just flew away. I was injured on the head, and I was under the anticipation, though I was like completely in my senses, that the person is going to escape. Fortunately, he just went few meters away and he fell down on this bike. So I was like, yeah, I'm not going to leave this man. And of course, he has committed a cognizable offense. He's already drunk. He has already hit me, and almost he has caused us a serious attempt to cause an injury. So what I did, that I chased that person who was just few meters away, and I ensured, and I will not highlight further on this, but I applied necessary force to restrain him till the police arrives. Police was contacted, the police arrived, took him into custody. So what I did was a private person's arrest. I arrested the man who assaulted me and who has committed a cognizable offense. And section 43 talks about, if such a situation happens, a citizen conducts a private arrest, he is supposed to hand over the custody immediately to the concerned police station. So as a responsible citizen, as a lawyer, of course, I contacted the police, restrained him, handed over the custody to the concerned police officer, and then we all went to the station and he was rearrested by the police there. So if a private person's arrest occurs, and if you see section 43(2) says, if there is reason to believe that such a person comes under the provision of section 41, a police officer shall rearrest such a person. So once you detain as a private individual, you can also detain. And then after you detain such a person, you have to hand over the custody to the concerned nearest police station or to a police officer. And the police officer will carry on with the provisions of the code on how a normal arrest is made by a police officer. So that is section 40. 44 talks about arrest by a magistrate. So a magistrate, of course, is here both the magistrates are concerned, whether an executive magistrate or a judicial magistrate. Simple distinction is an executive magistrate could be a government officer. For example, in metropolitan cities, even an assistant commissioner of police is considered as a special executive magistrate. So an executive magistrate basically will be a police officer or a subdivisional officer or a collector or a district magistrate who is basically a government servant, not a judicial officer. That is an executive magistrate. Or a judicial magistrate is the ordinary magistrate who conducts trials and who issues warrant and the other aspects of the criminal trial. So arrest by a magistrate is like if an offense is committed, similarly like how an officer can arrest. If an offense is committed in front of the magistrate can order an arrest, or a magistrate can order and commit to custody. In the second provision, it says he can't commit to custody, but he can order the arrest. So in such a case, once the arrest is ordered, the police officer will proceed as per the provisions of section 41 if it's a cognizable offense, or otherwise with respect to the bail aspect. So 44 talks about arrest by magistrate. Then 45 talks about protection of armed forces. So without the sanction of the central government or the state government, if suppose someone is on active duty, who's on the security of the nation or the security of the state, such person cannot be arrested if it in the line of duty that person has committed a particular offense which the police believes so. But so previous sanction of the government is necessary to see whether it was performed in the line of duty or otherwise. So only if sanction is given by the central government or the state government, the police are empowered to arrest a person of the armed forces. 47 talks about search of a place entered. For example, if suppose someone who has committed the cognizable offense has run into a place of a friend, so the police officer who's chasing the person who has committed the offense will have to enter the premises of someone who is not part of the offense, so who may not be aware that this person is accused also, but the police officer, or maybe shielding this particular accused from being arrested. So in such a case, the police officer, even without a warrant, is empowered to enter that particular place, search for the particular accused and take him into custody. He can apply necessary force also if the owner of the particular premises prevents him from entering that particular place. And if suppose the owner traps him inside the house, he can apply force to break windows and come out also. So basically the officer is empowered to do whatever is necessary to detain any person who is accused of a cognizable offense where arrest is necessary. So that is section 47. 48 again talks about pursuit of offenders into other jurisdictions, of course. So if Maharashtra police has registered a crime against so and so person, an investigating officer has reason to believe that I need to arrest this particular accused, he runs into another state, of course he can pursue that particular person to that other state, arrest him from there and bring him back here. So that is what section 48 talks about. I'll skip 49. 50, so the person arresting, if suppose he feels that there are some offensive weapons with me, if any gun or a knife or anything that is could be used for the commission of an offense, can be taken by the particular police officer who will arrest you. He will make a report of the same and forward all this particular thing that is recovered from such an accused to the concerned court who will be trying. In section 55 it says arrest can be made by a subordinate police officer on the order of a superior police officer. If a superior police officer is directing the arrest to a subordinate police officer, then the subordinate police officer will have to obtain an order from him. He'll have to make an order, give it to the subordinate officer, and if the subordinate officer on execution of that particular order goes to arrest someone, if that person demands to see the order made by the superior officer, the subordinate officer is supposed to show that particular person the order under which he is instructed to arrest that particular concerned person. So that is what section 55 talks about. Then 56 and 57, of course, person cannot be, it says it has to be the person who is arrested has to be taken to the nearest jurisdictional magistrate as early as possible. And 57 talks about that as early as possible cannot be more than 24 hours. So 24 hours ke andar, you have to produce the particular person who is arrested before the magistrate to seek further remand or further custody of the particular person for questioning or judicial custody, whatever it may be. But permission of the magistrate is required if you want to seek his detention further than 24 hours. That is what 57 talks about. So that is what every arrest made must be informed to the district magistrate of the for the divisional subdivisional magistrate of who all are arrested or how many people are enlarged on bail, or otherwise basically a compilation has to be made by the police officer how many people are arrested in that particular district or a division. That is what 58 talks about. Then 59 talks about discharge of a particular person apprehended, that unless a special order of the magistrate is there, the person or bail is there, the person who's arrested cannot be released. That is what 59 talks about. Again, power 60 talks about the power on escape to pursue or retake. For example, if someone jumps from your custody, someone who was in your lawful custody but escapes from your custody, the person can actually ensure that again pursue anywhere to India and then any place in India and ensure that the person is arrested. 60A talks about that arrest to be made strictly according to the code. So basically, it's like the law is making it categorically clear that if anybody is arresting, it has to be made as per the provision that I just read out between 41 to 60 of the code. Now I'll come back to the provision that I left. That is because those were concerning the rights of the particular person who is arrested. So, for example, 41B, this is very important for anybody to keep in mind when they are getting arrested. It says procedure of arrest and duties of the officer making the arrest. So first of all, the officer should be well uniformed. He should have his nameplate and the other identification signs which an officer, for example, like he should have a accurate, visible and clear identification of his name, which will facilitate easy identification. Basically, the person who's getting arrested should know who's arresting. That is one aspect. Then when he is being arrested, a memorandum has to be made. So memorandum is mostly like it's called an arrest panchnama made by the police, and it has to be attested by one witness who is either the family member or a respected member of the locality. That person has to attest this particular panchnama. This person is arrested at so and so time before me from so and so place. So basically, it acts like an added proof that the police came to arrest a particular person. He was arrested at so and so time in so and so condition, and so person has affirmed it. So that is the whole protective measure here, and it ensures that the rights of the accused is protected, so that everybody is well informed that so and so person is taken into custody and it is not an illegal detention. So, and it has to be countersigned by the person arrested, and inform the person unless the memorandum is attested by a family member that he has a right to reach out to a family member or a close of kin or a relative that I am being arrested and I am held in such police station for so and so offense. Basically, 41B deals with the rights of the accused to have a clear identification of the police officer who's arresting him, ensure that a next of kin is informed that the person is arrested and taken to so and so police station, and that someone has verified properly that the arrest has taken place as per the procedures of law. 41B talks about that. 41C talks about control room at districts. So the state government shall have, like at every state and every district, there should be a control room, and if an arrest is made, that control room should display that so and so person is arrested, like a general information available to the public: how many people were arrested today, what are their details, and basic structures, basic facts about the concerned arrest should be shown by such control rooms at the district and the state level, so that people are informed that an arrest has taken place and there are logs, proper logs about who is brought into custody. That is what 41C talks about. Then 41D, this is very important. This is where the lawyer's role is extremely important. 41D talks about the right of the arrested person to meet an advocate of his choice during interrogation. Now, this is where the law slightly differs in India compared to US laws and the others, because the person, for example, I'm an accused, I'm in the custody of the police. Of course, I have a right to seek a lawyer's assistance and to meet a lawyer. But it categorically says that during interrogation, you can meet a lawyer, but not throughout the interrogation. So basically, the police can prevent a lawyer from being part of the interrogation with the accused. So the police have clear liberty in restricting the lawyer at some point of time to speak alone with the accused. So you can't barge into a police station saying that I am the lawyer of the particular accused and I must be granted complete access to sit with the particular accused and be a part of the interrogation process. No, you don't have that particular right in India. So a limited right is given to the accused to have access to a lawyer, take necessary guidance, and to be part of the interrogation also, but not throughout the interrogation. It is specifically mentioned under Section 41D of CRPC. Now, 46 is very important. This is where the force aspect comes in. In making an arrest, the police officer or other person making the arrest can actually touch or confine the body of the person to be arrested unless there be a submission to the custody by word or action. This is very, very important. The police officer comes to arrest me. It's not कि they मेरे को घसीट के लेके जाएंगे. ऐसा नहीं है. If the police officer is coming to you, he's supposed to inform you that so and so offense has been registered against you. We have to take you into custody. So therefore, we are going to arrest you. Now, if you say, okay, I'm going to cooperate, you take me into custody, no force is supposed to be applied to you. You don't need to be hand changed or taken by force, or your body need to be touched. Nothing like that. It is specifically mentioned in CRPC. If the accused or the person who is going to be arrested is voluntarily submitting to the custody, then no force should be applied. When in case of a female, it is categorically mentioned that it has to be a female officer. If suppose for the person is not submitting voluntarily into the custody, then it is very, very important that the female officer has to be the one who should be detained. Now, I will give you a very interesting scenario in one of my cases that, again, I'll give you a live example to show you the reality, how there is a pros and cons when a female officer has to be present to arrest. So in one of my matters, my clients were ladies. So there was a huge assault taking place in the premises, and the person who was assaulting my clients were also ladies. And when the police were called, when the beat marshals came in, they both were men. So they were so scared to stop the fight from happening. And my client was a pregnant lady. So ideally, in such a scenario, everybody were looking at the police and asking them to stop, pull the woman aside, and ensure that the crime does not commit further. And that is the duty of the police officer. But they were saying that under the provisions of the CRPC, we are not supposed to touch the woman again, or else it will be a case against us. So the practical reality is that of course, it's the intention of the legislature is to ensure that no woman is abused in this process, or again, power should not be misused to detain a woman or touch a woman inappropriately while conducting an arrest, so that therefore a female officer is warranted. But in some scenarios, the necessity of a female officer to be there sometimes has, like in my case example, an offense was happening and police were not able to prevent it because all the parties involved were female. So the ground reality is that, again, the reason why that was, they called the female officers, of course, but they reached after half an hour, after everything was over. So then it was all taken to the police station and court later. But what I was intending to say is that the number of police officers and female officers are especially low in every police station. Hardly there are female officers. So therefore, of course, I think attempts are being made by the government to ensure more female officers are taken into duty. But there is a heavy shortage of female police officers available. And therefore, in such instances where females are the culprits or the victims, it is very difficult for male police officer to intervene. And sometimes they're just scared that a case will be made against them. That's a reality situation that I just told you. And one more aspect that in this particular section is, ideally, the section permits the police officer to use force as much as necessary to take the person into custody. But it categorically says that by using force, you should not kill the person who is particularly accused. So sometimes that is like an abuse of your power, that you use so much force on someone, you did not detain him, but you killed him in the process of arresting him. So that is not permissible. But there is an exception given that when the case concerns about a death penalty case, that means someone has committed an offense which is punishable by death or a life imprisonment, then in that case, if suppose an arrest is resisted, I will read the clear section so that it's very clear to all of you, or else you can read it simultaneously with me. Nothing in this section gives a right to cause the death of a person who is not accused of an offense punishable with death or with imprisonment for life. So that means the law is saying if the person has committed an offense punishable with death or an imprisonment for life, the police officer can take the life in case of the resistance. If that is where the encounters come, where people don't surrender voluntarily, so there firefight occurs, and then in return fire the police officer kills. So many fake encounter killings also stems from these powers that the police have. So but the reason is, powers are granted to the police officer to actually be used in a genuine circumstances, where for example you're fighting a gang of people or gangsters who are returning fire to you. Of course you can't just ask them please surrender voluntarily, they may not. So in a genuine situation, even if an encounter occurs at the time of arrest, it is warranted by law, and the police officers have power to do it. I think this is a provision which everybody knows. After sunset and before sunrise, a woman cannot be arrested unless exceptional circumstances occur. Then a female police officer will have to take permission from the jurisdictional magistrate to arrest a woman after sunset or before sunrise, if some exceptional circumstances occur. Otherwise, a woman is not supposed to be arrested after sunset and before sunrise. That is what section 46 talks about, how much force to be applied, how a woman has to be arrested, how anybody has to be arrested. That is what 47 talks about. Again, 49 and 50 talks about that the person arrested shall not be subjected to more restraint than is necessary to prevent his escape. So, for example, you don't need to arbitrarily chain his whole body just to ensure that he does not run away, because a person who is naturally given into voluntary submission, who's an ideal citizen, may not. So, unless the police can justify why force is applied or restraint is applied, only then, like for example, the person has to be kept under hand restraint or tied up, or other restraint should be used on the person when the police have reason to believe that the person may escape. Otherwise, no unnecessary hindrance should be caused. 50 talks about person arrested to be informed of the grounds of the arrest and the right of bail. Of course, if it's like I told you, in the beginning of this lecture, I told you about the classification of a cognizable offense and a non-cognizable offense. Now, a cognizable offense also has two categories. One is a bailable cognizable offense and a non-bailable cognizable offense. Now, if I were to give an example of a bailable cognizable offense, let's take stalking for an example. Now, I stalked a woman, of course, under 354D, she will go register an FIR, which is a cognizable offense. Under 354D, the offense of stalking is categorized by CRPC as a cognizable offense. Of course, it's a serious offense, but it is a bailable offense. The police officer can details, take your surety, and give you a bail forthwith. Because it's a bailable offense, you need not be detained or taken to the magistrate itself, and the police officer also have a discretion to give you a bail. Whereas in a non-bailable offense, the person has to approach the court for bail, and the police officer will take you to the magistrate eventually. So that is the difference between a bailable cognizable offense and a non-bailable cognizable offense. The reason why I explain that is 58 talks about obligation of a person making arrest to inform him about the arrest, etc., to a nominated person. So every police officer, other person under this code shall forthwith give the information of such place. Again, this is similar to the provision that I talked about. It is similar to the provision of section 41B that the person who is arrested should be informed why he is arrested, and his next of kin or a friend or someone who can come to his aid, and his access to have a lawyer and his right to have a bail in a bailable offense should be informed to him, so that he can arrange for sureties or someone, and he can reach out to the next of kin and get it released immediately. 58 talks about that. 51A talks about the arrested person. Like, for example, if you're taken into custody, of course, you will not be allowed to have all your stuff with you. For example, you can't sit and WhatsApp in a cell in a police custody. So, of course, they will take your phone into custody, or your wallet, or whatever is in your possession at the time of making an arrest, which apart from your clothing and your basic necessity that is on your body, everything else will be taken. And here the police officer is supposed to make a proper receipt, and it is a receipt showing the articles taken from your possession, and it has to be preserved and given back to you once everything is settled. But they will seize all that and make a report, and it is your right to have the report verified and ensure that a proper report is made, that whatever you had in your possession is properly accounted for by the concerned police personnel who has taken them from you, seized them from you on account of your arrest. 53, okay. Examination of accused by a medical professional. Now, this is a part where if suppose you're arrested and you're taken into custody, the particular person has to be examined by a medical practitioner. Here, the thing is that, if suppose a police officer feels that, let's say a drunk driven case. So, for example, to show that the blood alcohol level in the particular person is of offensible quantity, then the police officer will have to definitely medically examine you and get a medical report in favor of the prosecution to show that you were drunk and your blood alcohol limit was above the permissible limit. So in such a case, the police officer will take you to a medical practitioner, and you have to cooperate, or necessary force can be applied to ensure that your cooperation is done, so that details are taken from your medical report can be made against you that you have committed this particular offense. So the police officer can subject you to a medical test. Whether you like it or no, you can be forced to give that medical test, because it is to prove the commission of the particular offense. That is what 53 talks about. 53A talks about examination of a person accused of rape by a medical practitioner. Of course, to prove an offense like rape, so even the accused of the rape may have to cooperate. If his cooperation is not there, the point is crucial evidence can miss. So therefore, it is important that the person have to give his medical evidence, whatever is needed to prove the offense of rape, and his DNA profiling or whatever to prove, ensure that the prosecution needs as an evidence can be collected from him, whether with force or without force, if there is cooperation or no cooperation from the accused who is arrested. So that is primarily for rape, to prove in rape cases where the accused has to cooperate with the medical examination. Now, this is the part where the rights of the victim again comes in. Examination of an arrested person by a medical officer. Now, this is very important, sometimes, especially custodial deaths, custodial torture. To prevent that particular aspect, CRPC has provided this guideline to ensure that you are not abused, that no third degree treatment is given to you, and ensure that there is no injury or other aspect against you. So to prevent this particular aspect, whenever you're taken into custody, you are supposed to be taken to a medical practitioner. He has to see whether there's any injury mark on you, whether the police officer has committed, so that it can be clearly seen that no injury has been committed against you by the concerned police officer, and they will also have a proof, sir, everything is okay. So therefore, and you can have a right to have that particular medical report which has been prepared after examining you. You can also have a copy. The accused can also have a copy of the particular report. That is what section 54 talks about. 54A talks about the identification of a person arrested. The magistrate can ask the accused to cooperate with the identification parade, so that whoever is the victim or the witness can ensure that the proper person is arrested and he is the one who has committed the crime. So the magistrate can force you to be part of the identification process, and you can't deny that. That is what 54A talks about. 55A says health and safety of the person arrested. So it shall be the duty of the person having the custody of an accused to take reasonable care of the health and safety of the accused. So it is categorically mentioned that health and safety of the person, of course, all reasonable care and health of the accused has to be taken care of the police officer and that or the police station which under which the custody person is. So it's binding on the police officer to ensure that health and safety of the person arrested or who is in your custody is maintained and taken care of. I think that is in 60 and 60A. So we are done with the process of arrest, like the thorough explanation of section 40 to 60A of CRPC is given by the by the Code of Criminal Procedure regarding arrest. Now, one aspect I though mentioned when we were talking about the medical report, there it has so happened that CRPC mentions all this very beautifully. And when we read it, we get a sense of security that the police are bound to do so many stuff. But in one of my cases, that my clients were arrested and no medical report was taken that there is no injury or stuff like that she is going through, and she was actually in her menstruation cycle and she was suffering heavy pain. In a lockup there will not be much amenities for her, so basically there was a harassment in that aspect, and in the she was not taken for a medical report. So in order to prove that if the procedure was followed diligently, she would have had to report to show that I was harassed to that degree and I was not subjected to a medical examination, though there was no other physical torture expressed as such. But this is a fine example about how, though in CRPC provisions are written, but the reality of it and the degree of its implementation is not much. Even when, for example, let's say arrest, though it is said that in the arrest panchnama, a person staying in the locality or your family member signature and all has been taken, nothing has been done. Sometimes you're just taken by the police officer, you're taken to the police officer, then later on, like a formality, they will start their questioning and all, and then they'll just inform ki tumko kisi ko bulana to bula sakte ho. That is how it is done. And arrest panchnama is prepared later, like he arrested. Sometimes it so happens that a person who comes to surrender to the police station or a 41A notice is issued, वो आने के बाद तभी आप पे उठा लेते, arrest कर लेते. This is the reality. This has also happened where, because generally sometimes police does not want to go to the trouble of going to your home and picking you up also. They will call you, आप आ जाओ ना, बस 2-3 सवाल पूछना है. They will say, they'll call you and they'll arrest you. This is where the provisions of the bail come in. So when you get a 41A notice, nowadays the trend is, even sometimes I also advise clients, you take an anticipatory bail, because sometimes when you are clear, and I have to be very frank because I've seen the reality. Sometimes, like I said, the provisions regarding arrest, though you're supposed to exercise as much restraint when you believe that the person is cooperating, arrest is not required. Still, sometimes money is given to police officers to arrest, even though it's a cognizable offense or not punishable more than 7 years, just to show some reason and pick up. So sometimes, that threat is always there. If you buy the investigating officer, the person comes and arrests you. So to prevent that, as a legal mechanism for an accused against whom a false case has been instituted, the provisions of anticipatory bail come in. Section 438 of CRPC, where you approach the Sessions Court or the High Court, and that is called the pre-arrest bail. You tell the High Court or the Sessions Court that I'm falsely entrapped, I may be picked up by the police, or I've received a notice under 41A. Like I told you, sometimes in 41A, you receive the notice, you go for cooperating with the investigation, they arrest you then and there. So this is like a very unfortunate and unpredictable circumstances. Of course, you can show that that arrest was completely unnecessary. You can go to the police complaint authority, the State Human Rights Commission, report to the senior officers. Of course, you can prosecute them. But sometimes the liberty, like I said, is very important. You lose your liberty, then you have to fight the police officer. So in one of my cases where I told you that the right of one of my accused, even though they cooperated with the investigation, they received the 41A notice, they went to the police station, their statements were recorded, and after that they were arrested. So right now they have approached the police complaint authority also, and a writ petition has been filed for contempt in Arnesh Kumar case. So we are pursuing a case in the Honorable Bombay High Court against the particular Assistant Commissioner of Police and the concerned police stations for defaulting the conditions given in the case of Arnesh Kumar, as well as section 41A, 41 of CRPC. So this is like a reality where colorable use of power happens, and most of the times police misuse their power to arrest. So therefore the courts have a huge role and lawyers have a huge role in ensuring that the rights of their clients or the person who may be accused for a false case can be protected using the provisions of anticipatory bail. Now that is one aspect of arrest. I think more or less I have given a deeper understanding about how the process of arrest works. Now, and a very interesting aspect which goes along with arrest is detention. Now, to prevent a cognizable offense under section 151 of CRPC, the police officer can detain you. But of course, detention, like I told you, it's not an arrest. We can't. Now, I think this can also be clear from this. I think this was like a huge UN cry when Article 370 was diluted under the Jammu and Kashmir Public Safety Act. Many leaders in J&K were detained for more than 6 months. Now, if you say as per section 167 of CRPC, any accused for any particular offense, if investigation is not completed within 60 days or 90 days, the particular person has to be released under default bail. You can't keep indefinitely someone in custody. But the detentive laws are different. Detention laws apply differently. So the provisions of CRPC are overridden by the particular statute. For example, in CRPC, the maximum detention allowed under default bail is 90 days. But for example, you take like an act like an Unlawful Activities Prevention Act. In that, the detention can be extended up to 180 days. So the provisions of CRPC can be overridden by special statutes, and special statutes do exist. In Jammu and Kashmir Public Safety Act, like I was telling, the leaders were detained more than 6 months. And I think it went to 1 year, they were under house arrest. So it's also a detention. Their liberty is arrested. Now, the point is, we can't call it an arrest under CRPC, but under that particular special statutes made for that particular reasons. And that may differ from state to state or central laws. So I'm not going in depth to the special statute, but special statutes do exist. And I think the provisions of bail to mention, of course, like an ordinary bail, once you're arrested, you can of course approach the honorable magistrate who is actually who is detaining you further into police custody or judicial custody for bail there under section 437 of CRPC. Or you can approach under section 439, which is a special jurisdiction given to the sessions court and the high court to grant bail in any case. So this is the opportunity that I already told about anticipatory bail, which applies at an earlier stage, where you can apply for an anticipatory bail even before the FIR is registered, or even when there is no FIR registered. You know that an FIR is going to be registered against you for so and so offense as a fake case. You can approach for an anticipatory bail then and there itself. So this is the provision aspect regarding bail. I covered regarding detention. I think more or less we are covered here. And I think inquiry aspect. Now there is a small difference, a thin line of difference between the word inquiry and investigation. Sometimes it is interchangeably used also, but there is a huge difference. Now, when we use a term as an inquiry under CRPC, there is an inquiry. For example, I will give you an inquiry that the special executive magistrate takes place under chapter proceedings. Now, chapter proceedings is given like the chapter of the concerned CRPC. It is chapter 8 of CRPC. So the police officers and people who are very accustomed colloquially with the term call it like chapter proceedings, like chapter 8 के अंडर के proceedings को आप chapter proceedings बोलते हो. Section 106 to section 124. This is basically titled as a bond for keeping good behavior. Now, for example, let's say an FIR is not registered, and in a locality, some people constantly keep fighting or constantly keep committing non-cognizable offenses where police can directly not investigate. Multiple NCs are registered against you. So in order to ensure that you don't disturb the law and order situation, the special executive magistrate, who in Mumbai and the other metropolitan region is an assistant commissioner of police, who has been accorded the powers of a special executive magistrate, can issue a notice to you and ask you to come and cooperate with an inquiry against you, why you should not be forced to sign a bond, which may be with a surety amount of 25,000, 10,000, 15,000, based on the intensity of the law and order issue that you're creating. Why that need not be made, why you should not be made to sign that particular bond. And if you do not sign the bond, and if you're continuing with the law and order situation, the police officer can detain you as far as he thinks is reasonable. So this again is a provision which is contravention to arrest, but happens simultaneously, which is provided under CRPC also. So the whole reason why I've told you this proceedings which will happen under the special executive magistrate is like an inquiry, not an investigation. Because an investigation, like I told you, under 154, when an FIR is registered, a thorough investigation is done. A similar example of an inquiry that I can give is under section 174 of CRPC. Now, under 174 of CRPC, if a suspicious death occurs by suicide or by some other suspicion reason, and the police officer wants to first ascertain whether this is a cognizable offense or a crime committed or a crime has happened or a murder has occurred or something unnatural has occurred, which is like, a crime, a clear crime. To ascertain that, he can conduct an inquiry under section 174, go to the spot, interview people who are accustomed to that. Now, this is a very important aspect for me because I have a custodial death case going on where, despite it being a clear-cut murder, the Bombay High Court is currently hearing it. In that particular case also, the controversy erupted that the person died in the custody of the police officers, and he died in front of the witnesses. He was beaten in front of the witnesses, but the police officer, despite all our intervention, did not register an FIR. And for one long year, they investigated the case under section 174 of CRPC, where it's just a mere inquiry. Because under the inquiry, still till you come and forward the report to the magistrate or register an FIR, nobody would be arrested. So though the police officer were suspended by the commissioner, still they were given a free pass by delaying the investigation and using 174 as a ruse. So it is an inquiry, but not an investigation. Similarly, 176 in cases of death in custody, particular judicial officer, a magistrate can conduct an inquiry. So there also the term inquiry is used. Similarly, if suppose an cognizable offense is disclosed and the police officer is of the belief that there is no cognizable offense done, he can conduct a preliminary inquiry to ascertain whether a cognizable offense has been done. So this is called inquiry. Similarly, if a magistrate, you make a direct complaint to the magistrate of a particular offense, and then if an offense is committed according to you and you have all the proof and you want to initiate a direct magistrate a private complaint before the magistrate through your lawyer, and if the magistrate is not convinced by the evidence that you have or the submissions made by you, he can himself conduct an inquiry or direct a police officer to conduct an inquiry. So something that is not a proper investigation as per CRPC will be part of an inquiry. So inquiry and investigation, this is the difference. Like, something that does not follow a thorough procedure of investigation will be called an inquiry. In an inquiry, a person has more discretion. He need not follow the provisions given under CRPC and the guidelines and the timeline or the way the particular investigation has to be done, but he has more laxity. So that is an inquiry. In some cases, inquiry is fine, but some cases, investigation is fine. Even in, I think that very controversial case of Parambir Singh also, the Bombay High Court directed the Central Bureau of Investigation to conduct a preliminary inquiry for 15 days. And then if there is an offense, you register an FIR. That is what the High Court directed. So an inquiry is to just ascertain the overall aspect, not a thorough aspect, just to see whether there is an offense. And an investigation is like a thorough investigation into each and every aspect of the case, after which the person would be prosecuted in a court of law. So I think inquiry is covered, bail is covered, arrest is covered, investigation is covered. Now I think we can proceed to Q&A.
This is under section 41A.
Okay.
Could you shed some more light on subsection 4?
Where such person at the time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may have been passed by a competent court in this behalf, arrest him for the offense mentioned in the offense. Now, to be very honest, I have never seen this section being used in practicality. Like, under section 41A के 4 में किसी को notice violation दिखा के arrest किया है. I've never seen this in practicality. But if you see by a bare reading of the said subsection, if you see, it fails to comply with the terms of the notice. Now, for example, the terms of the notice would be basic, ma'am, that, if suppose I have instructed you to come at 2 p.m. to the concerned police station for interrogation, you do not comply with the terms. Ideally, right. This is given as a provision, but like I told you, just because you did not comply, abhi 2 ke jab pe aap 2:30 aa gaye, that can also be considered as a breach of the provision. So, but in reality, if you see, आधा घंटा आप late हो गए और आपको arrest कर दिया, is completely unreasonable. If the courts are to intervene, then the police would be completely held wrong in this. So I think section subsection 4 only talks about a situation where if the terms are not complied with, I think the terms are not complied with should be reasonable. In our country, whatever law is written, you can't stick to the word of it. It is binding on every public authority and the courts that the principles of natural justice are always upheld. So it has to be reasonable, or else it is always a colorable use of power. In case if you just stick to the word and say, I have this power, I can do this. No, in our country, that is not acceptable. So subsection 4 deals with breach of the terms of the notice. And I think competent order passed by the competent court is when the police officer can inform the concerned magistrate or the court that the so-and-so person against whom a 41A notice is issued is not cooperating with. So suitable orders can be obtained from the court also to detain that particular person or arrest that particular person on the breach of the same.
You mentioned earlier that the police tend to abuse this, under subsection.
Yeah. I've had persons, so many cases, not just one, in so many cases, police have done it in my case as well. So
Hmm.
generally, if suppose I see that for example, let's say an SC/ST atrocity act, this is a very, so some cases are very volatile because sometimes it is or a 498A case, sometimes the statement or a rape case, sometimes the statement completely rests on the statement of the victim. So now it may be her word or his word against mine. Now, in
Hmm.
such a situation, if you are issued a notice under 41A notice, don't you think, ma'am, it is very riskier to go to the police station? Because the police may say, just ask you some questions, and then the baad mein say, I think you have committed the offense, you may just flee tomorrow, and they just take you to custody. They
Hmm.
will put it in writing that so and so reason is why they arrested you. So
Hmm.
that the aspect of 438 bail, the anticipatory bail that I mentioned, is very, very important. So you
Right.
must operate. See, the whole aspect is if they arrest you on the allegation that you breached the terms of 41A, or they figured out a reason later to arrest you after the issuance of notice, the whole point is police are duty bound to justify it also. Now the question is simple. Sometimes if you go there, you get arrested unreasonably. Like I
Hmm.
said, you can prosecute the concerned police officer,
Hmm.
but prosecution of the police officer comes later, right? You are in
Hmm.
detention now. So sometimes it's a tough call that clients have to take, whether they have to approach for pre-arrest bail, that is anticipatory bail, or they should take the chance of going to the concerned police station and cooperating with the investigation. Ideally,
Right.
a police officer, like I said, if you know there is no evidence that the police has against you, then you can confidently cooperate with the investigation, go as per the terms of the notice and cooperate with the investigation. Because
Hmm.
if they arrest you, it's like a huge blunder. They may detain you for 24 hours. After that, they'll have to take you to the magistrate. Your lawyer will tell the magistrate that there was no grounds to arrest. You cooperated with the investigation, you appeared as the police instructed, and you will be released on bail.
Hmm.
So ideally, in when a citizen who is smart enough is involved, who knows their rights is involved, the police generally will not try to arrest you if a notice is issued and if the offense is not of a grave nature.
Thank you.
Notice you said 41A is issued by a police officer, suppose in this year, 2020-21,
Okay.
and the matter is going on, but that time he does not make any arrest. Can he do an arrest later on at his sweet will, anytime
Yeah,
later?
like I told you in my matter, the same thing happened. Notice बहुत पहले issue किया था, and later on they were arrested. And they applied for an anticipatory bail. Now, I'll give you a nice catch here, Dr. Kinjal. What happened in my case is it was an atrocity case. So, Section 18 of the SC/ST atrocity case bars an anticipatory bail under Section 438. So the statute overrides the CRPC in this particular case. So you all can note down, you can research later. Section 18 of SC/ST Atrocity Act bars the application of Section 438, that is for anticipatory bail in cases under SC/ST Act. But there is in landmark judgment of Prithviraj Chavan, the Honorable Supreme Court has said that prima facie case has to be convinced. If there is no prima facie case, 438 bail can be given. So because of the previous laws that my clients had, they could not justify before the court, and the investigating officer gave a false information that prima facie case is there. So the court, because of the bar under Section 18, came to reject the anticipatory bail. And they were granted interim protection before the anticipatory bail was finally decided. When they were granted the interim protection, they went to the police station. My clients gave their statements, cooperated with the investigation as per the notice which was given 2-3 months back before their bail and all. They cooperated, and after the ABA was rejected, they were taken into custody. Full cooperation was there. There was absolutely no reason for arrest, but still they were arrested later on. So notice was given long back, but arrest was made long time later.
But
So
once whole inquiry is done, sir, then what is the need for arrest at that time,
yeah,
sir?
this is because vendetta, because my client is a social activist and a lawyer who has actually filed, like I told you, it is one of those cases where she has initiated prosecution against a concerned police officer. So when there is a vendetta issue between the police officers or a lawyer or a social activist or a civil activist, where there is enmity existing, this is where I told you, Dr. Kinjal, that there is a clear colorable use of power and abuse by the police when the police wants to take revenge against you. Now the police are running behind my client to withdraw the case from the High Court, because now they understood that they violated the Arnesh Kumar guidelines. So they are requesting my client that please settle the matter, don't take it forward. So the whole aspect what I'm trying to tell here is that you can teach a lesson to the police officer later, but there is always a threat that sometimes they violate the 41A guidelines and they just arrest you. Sometimes this police officer thinks that you will not fight them. That is a confidence that some public authorities have in our country. कि कौन जाएगा हमारे खिलाफ लड़ने के लिए. So that is an aspect. But अगर आप लड़ सकते हो तो आपके साथ ideally mostly पुलिस कभी पंगा लेगा. Or if you are informed, you know your rights.
So, sir, I have a very small question.
Yeah.
Section 167 was there, which talks about the 60 days and 90 days time period.
Okay.
So, can you brief that rule? Is it inclusive of those 15 days as well?
Oh yeah. From the time that you are taken into custody, those 90 days and 60 days gets calculated. Basically, your detention is calculated from that first day when you are detained, because actually 167, if you see the first paragraph itself says the intention of the legislature is that you 24 घंटे में police officer is supposed to complete the investigation. So 167 starts only by saying if the investigation cannot be concluded in that 24 hours of detention, then the magistrate can order further remand into police custody or a judicial custody. And his maximum period and power granted to the magistrate is 60 days when the offense is not punishable with death or life, and 90 days when the offense is punishable with death or life. So basically 167 में जो safeguard आपको दिया है default bail का on lack of investigation will start from the first day that you're detained.
Okay, inclusive of those 15 days. Inclusive of that, exclusive of that 24 hours, right?
Actually, if you say detention has started from the police, right? Magistrate is only permitting for the detention. तो अगर आप detention देखोगे, तो detention should be inclusive of the 24 hours. If you see, why will that one day be excluded? Because that one day is also part of investigation. Like I said, 167 starts by saying if the offense is not completed within 24 hours, further detention can be granted by the concerned magistrate. तो वो एक दिन भी कंक्लूड होगा और फर्दर रिमांड भी कंक्लूड होगा और पूरा 90 डेज, बिकॉज इन्वेस्टिगेशन मैंने आपको बोला ना, जैसे ही एफआईआर रजिस्टर होता है इन्वेस्टिगेशन चालू हो जाता है. तो इन्वेस्टिगेशन चालू हो गया और चार्जशीट अगर 90 दिन के अंदर सबमिट नहीं हुआ या 60 दिन के अंदर सबमिट नहीं हुआ, तभी आपको डिफॉल्ट बेल का राइट आ जाता है. दैट मींस द पर्सन हैज नॉट इन्वेस्टिगेटेड इन दैट पर्टिकुलर टाइम फ्रेम गिवन टू. सो देयरफॉर his right to default bail arises and he can be released. Understood?
Okay, sir. Thank you. Yes, I got it.
Little further question I wanted to ask you. Sometimes police officers submit charge sheet before the magistrate, final B or final C, where they are
B summary report or C summary report?
Yes. That's what I wanted to say. In that case, suppose the victim or the informant or the complainant files protest petition against those summary B or summary C. Okay. In that case, I wanted to ask you, this protest petition, if a magistrate hears before him, is this protest petition is similar to the other petitions, and is the magistrate is mandatory to record the daily report, that is Rojnama, if the hearing is going on for two, three times?
See, the whole point is, this is a separate provision where if suppose a B summary or a C summary is actually, or an A summary is made, because in one of my cases, the case was genuine and an A summary report was filed. For example, that was also an interesting case, like, where a person was cyber stalked. The victim was a female who was my client. So her morphed picture was sent to her on WhatsApp. So again, it was sent through WhatsApp using a virtual number. Now, tracking a virtual number is nearly impossible for our police force because they lack the technology to do that. So under the Information Technology Act, there are provisions which mandate that WhatsApp and other intermediaries are duty bound to cooperate with the investigating agency and investigate for them to give technical guidance to the concerned police officers. So because the police officer did a very preliminary inquiry कि कोई मिला नहीं, CDR record, SDR record निकाल दिया, submit कर दिया, and then बाद में they just said कि everything is done and we could not find the culprit. So I filed a protest petition on behalf of my client, and then the protest petition was granted, and further investigation under 173, it was granted by the magistrate, and investigation happened in that particular case. So in my case, it was not followed as per like case number. If that is your question, sir, कोई case number या proper hearing like जैसे बाकी केस में होता है, वैसे मुझे accord नहीं दिया गया था. I was heard and order was made for further investigation. Like proper case number was not given to the same. So I used to mention the CR number that in so and so case, it is not a charge sheet. It is a normal, it's a summary, B summary or C summary that is submitted. So therefore I want further investigation for that particular.
Similarly, I had filed a protest petition, and since 3 years, the hearing is going on, and unfortunately, some power politicians are involved in this case.
No, so then sir, let me on the face of it, from what you just told me, 3 years, such a long time, because my thing was completed in just 1 month. In 1 or 2 hearings, it just got over. So I think there is parties who are there involved in your particular case who have vested interest to ensure that the case is not heard. So something is happening either through your lawyer or some other defect because of which the court is not hearing you.
Actually, I myself have filed this protest petition.
What is the problem? Why is the court not hearing you?
Actually, thing was this way. This was 420, 417, and 34 in my case.
Okay.
And I have filed this protest petition. And from Mumbai, I used to go to somewhere in Kolhapur by traveling. I myself is a lawyer as well as I am working as a government accredited journalist now.
Okay.
And thing was this way, some power politicians have managed this term. And I used to make the prepare the mind of the magistrate to issue a process. And after making their mind, that magistrate used to get transferred to some other place.
No, but
like that.
Process under protest petition, sir, I don't think so. How that goes well? How did you pray for issue of protest? Because issue of protest happens when you initiate a private complaint before the magistrate.
No. Actually, FIR was registered against them.
No, but you said it's not a charge sheet and a B summary or C summary was filed, right?
Yeah, actually, B summary was filed by them.
Exactly. So B summary shows that there is no merit in the case, according to the prosecution, the police. You filed a protest petition. So when you file a protest petition and the police believes there is no case, the magistrate is supposed to look at your arguments on merit. And what is your submission to show that there is some evidence which police have missed and police have not done a proper investigation. So the magistrate, whoever the magistrate is only supposed to focus on this aspect, whether your submissions show some evidence on record to show that the police officer has not made that evidence part of his investigation and therefore he has done a bad investigation. That is what you have to highlight in your protest petition.
Yeah, I had highlighted. And
then what is the problem?
Actually, around 60-70 documentary evidences along with video recording and audio recording I had submitted before the magistrate. Okay. But thing is this way, till 5 days before, actually what happened, कि the चार magistrate change हो गए, transfer हो गए. Or for PT issues, they used to ask me to give me next hearing. And 4 days back, exactly on 10th of this.
Sir, from just what you just told me, अगर चार magistrate इतने fast rate में अगर change हो रहे हैं और आपको वापस date चिपका रहे, then there is some issue involved behind you. कोई तो like behind the scenes कुछ हो रहा है आपके case में.
Behind the scenes हो रहा था.
Behind the scenes हो रहा है, तो then what you should do, because it's like a long delay of 3 years, आप writ petition file करो High Court and you ask
yes sir.
the timeline for the magistrate to pass an appropriate order in your case on your protest. Perfect is for you in your scenario is you have to approach the High Court under the writ jurisdiction.
Actually, what has happened? Finally, I had submitted one application 3 days before to the 4th magistrate. Either you reject my protest petition or pass a order.
Exactly. Everybody has a right to a speedy trial, sir. In a way, you are also looking for a trial to get justice. So, because you have a right to speedy trial and 3 years में अगर report पे ही कुछ decision नहीं आ रहा है, then your fundamental right is being violated. You should approach the Honorable High Court for that. So that is the remedy that lies in front of you. If the new magistrate also who's hearing your matter does not pass an appropriate order in a reasonable time, you approach the High Court, sir. That would be my recommendation.
It's a question regarding anticipatory bail. What would you suggest, or it would depend on a case-to-case basis, whether to approach the Court of Sessions or directly the High Court?
So the whole point is, if suppose you feel that your case has good merits, okay, and then that that you are very clear on the point of law and the point of facts, going to the Sessions Court will help you have a second chance. Like, for example, when you approach directly the High Court, of course, there is no jurisdictional bar on you directly approaching the High Court. But what happens is that sometimes, because of the lawyer's inefficiency or the narration given by you or the evidence brought on record, if it is not proper, if the High Court rejects, then the only remedy that you have is a special leave petition, which in normal scenario will not be applicable, which is very difficult to win that way. But otherwise, you are rendered remediless. Or else you'll have to approach for you'll have to, make a new bail on that aspect. So which is again very fruitless. So therefore, it is advisable to apprise the sessions court first. In case by any chance your bail gets rejected, you have a second chance to go to the High Court, and the High Court will have the advantage of the observation made by the sessions court and the order of the sessions court, which is in rejection. You will also have an idea what is the judicial mind applied in your case, and where does the court feel you are, you should not get the bail. You will also come to know. So therefore, approaching the High Court is a little more riskier than approaching the High Court after the sessions court. That's all. Otherwise, if you're like damn confident about your case being an open and shut one where it's completely false and anybody would believe that, and you have the evidence to support that, you can approach the High Court directly as well. So again, a matter of discretion, I would say. The first question I've been asked is, can the accused ask for medical test from his own private doctor or private labs as second opinion for his own safety? Now, again, the whole point is CRPC does not specifically mandate such a privilege because of that, unless there is a disputed medical report that is coming against you. So in case if suppose you have like a medical report which is completely against you, you will have to mention it. For example, if you notice, when an accused is brought before the magistrate asks कि पुलिस के खिलाफ आपको कोई शिकायत है क्या? This is a question the magistrate is duty bound to ask you. The judge is supposed to ask you, पुलिस के खिलाफ कोई शिकायत है क्या? Provisions of the CRPC says कि आपका मेडिकल टेस्ट होने के बाद आपको मेडिकल रिपोर्ट देखने का हक है. तो अगर आप वो मेडिकल रिपोर्ट देखते हो और आपको लगता है कि ये झूठा मेडिकल रिपोर्ट है, something has been inflicted on me, तो आप बोल सकते हो as part of पुलिस के खिलाफ का शिकायत that I have so and so grievance against the concerned police officer, and you can pray before the magistrate through your lawyer that a medical test be given, and the court may order a medical test in such a scenario if it is convinced that you require a second opinion from a medical test of a private doctor. So that is my legal opinion with regard to the question that is asked. The first question. Advocate Jitesh sir is asking me, if suppose someone cheats you with a false promise. In this particular case, he's asking me if A offered a job to B in a big company, and just to get the job, he asked for a bribe of 5 lakhs, and B cooperated with that and gave the 5 lakh rupees. Can Mr. B also be held liable for this particular action? Of course he can. And if you see, there was a nice controversy that erupted. I think the Madras High Court is dealing with this issue, where a retired judge of the High Court offered 8 crores rupees to some middleman who promised him the job of the governor of the state. I think this, most of the people should be accustomed, because I've seen multiple news reports on this. So there is a PIL filed again in the court that action should be taken against a judge also who gave the 8 crore rupees as a bribe to the middleman who offered the governor's position to the retired judge. So to answer your question, sir, of course, if suppose giving the bribe is as faulty as demanding the bribe. So if you cooperated willingly into that कि हाँ आप कर दो और मैं आपको इतना पैसे देता हूँ, you are equally liable to be punished under the relevant provisions of the Prevention of Corruption Act, and you will also be liable. तो bribe देना भी गलत है और bribe demand करना भी गलत है. And which kind of action we can take against him, again, like of course the whole point is cheating में तो बैठता ही है, so you can always file. So the last part of the question is, what action can be taken? So the person who has taken the money from you, of course, has committed cheating against you, but he can also come with a counter case that आपने भी दिया. So if there can be a cross case on the aspect of you giving the bribe voluntarily to him, and a cheating case would lie against the person who took the money from you because he has definitely cheated you. So the aspect is, case can lie against both of you. That is what I feel. If someone misuses the power, what to do next? For example, police judge sometimes sitting in upper level doing totally wrong. I mean, the whole point is the aspect of anybody misusing their power or using, like I said, colorable use of power or abuse of power always has to be dealt with by the appropriate authority. In our country, the advantage that we have is, if, for example, police completes an offense, we have the provision to approach the police complaint authority for the offense, or the State Human Rights Commission, or the National Human Rights Commission. So the National Human Rights Commission, the State Human Rights Commission, and specific authorities or committees made by statutes are there to ensure that there is no human rights abuses. So if you see that if a public officer is committing a crime, of course, if you have enough resources to hire a lawyer under the relevant provisions of IPC, you can file a case, a private complaint before the magistrate against such a public officer, and the investigating authority would be asked to obtain a sanction from the government to prosecute such a public servant, because the public servants have a higher degree of protection accorded to them by law, because if in line of their duty they committed a mistake, then of course they should be protected. but otherwise they can be prosecuted on the face of it if it is clear that they abuse their power. So the State Human Rights Commission and the National Human Rights Commissions are the most important organs in ensuring that no public authority misuses their case for a common ordinary man. And because you don't need a lawyer to file a case before the State Human Rights Commission or the National Human Rights Commission. So that is one aspect. There's another question, sir. Please explain in short A, B, and C summary report. Advocate Nilesh Sharma. Of course. So if I were to explain in short, A, B, C is A summary report is filed by the police when the police finds the case to be genuine. So the case is genuine, but the police has not got any actionable evidence or the accused himself in the particular case to proceed further with the charge sheet. So basically the police are saying, मेरे से investigation नहीं हो रहा, या फिर मैं investigation नहीं कर पाऊंगा. In short, because of the procedural infirmity, all the technicalities involved, or the impossibility of situations of facts involved in the case, I can't investigate, or I can't gather the evidence, or I can't find the accused. In such case, the police can file an A summary report before the magistrate. I think the Arnab Goswami case is one of the huge highlight of the case. Arnab Goswami was arrested after the magistrate granted permission, after the police opened the investigation in an A summary report filed before. So the case was closed temporarily because the police could not gather evidence. But later it was opened against Arnab Goswami after finding new evidence as per the A summary report. So that is A summary report. Case genuine hai, but evidence nahi hai, or accused nahi hai. Uske liye no charge sheet. Therefore, A summary report is filed. B summary report is filed when when the police officer feels there is no merit in the case. It could be a false case, or it could be like, it is completely unconceivable or unfathomable for the police officer to believe that the so-and-so offense has happened. So the police officer will say that, the case has no merit and therefore no investigation can happen. Therefore, a B summary is filed. C summary is filed when a case is filed on mistaken belief. For example, I filed a case of someone kidnapping my son or a daughter. Later on, I come to know that he is found in the market playing with his friends, or somewhere in the garden playing with his friends. So basically, I filed an FIR out of a mistaken belief that he is kidnapped. So an FIR is filed, investigation has to be completed. So the police officer, on finding that the FIR was not meritorious and was filed on mistaken belief of a crime happening, will file a C summary report. So this is like the basic difference of A summary, B summary, and C summary.
If there is a case, like suppose any kind of 498 case on my client or something, like basically 420 case on my client, and we know that basically it's a false case produced by the petitioner. Okay. Then basically, can we go directly, means getting in the trial court and all those things, can we directly go to for the squashing? It is possible.
Of course.
How is the experience in that, sir?
Of course. So I have filed several quashing cases. A lot of cases are pending, and it is almost at a very good stage because the High Court proceeds faster than the lower court when it comes to quashing, comparatively in my experience. So if it's like a clear-cut case that, it's a vexatious complaint against you and you have evidence to show that, everything is fake against you, because investigation and trial court में पूरा discharge का proceeding सब आगे बढ़ने के लिए बहुत time लग सकता है, सालों निकल सकते हैं. So if you're confident on the aspect that your case is like open and shut, or आपके खिलाफ false case हुआ है and you have the evidence to support your case, you can directly proceed the Honorable High Court under the jurisdiction and inherent jurisdiction of the High Court under Section 482. So you can seek for quashing of the FIR. It depends on the merits.
Sure. Thank you.
So if you have good merits, you should proceed. That's what my recommendation would be.
Sir, actually, that case corruption one, you said that person also will be liable for cheating along with the person who gave the bribe.
No, not for cheating. Under the relevant provisions of the Prevention of Corruption Act. And the whole point is Prevention of Corruption Act is morally liable to public authorities. So ideally, it will be a hard time proving that, a layman ke against wo file karna, it's like difficult that way to find the appropriate provision and to get him prosecuted. But of course, I think some provisions will clearly lie against him because he has voluntarily paid the bribe. So bribe dena bhi Prevention of Corruption Act mein covered hai.
And the person who took cannot be held liable for cheating, right? Because
he will be,
anyway, he
was cheating clearly, na.
Like, sir, I think that he was like having committed a promise of something that is not legal. Like, it's like I promised someone that I'll murder person X, and now when I didn't murder person X, I am being held liable for cheating.
No, but now the distinction here is, Gauri, अभी आपने promise किया कि मैं murder करने वाला हूँ, बराबर?
Yes, sir.
तो वो illegal on the face of it है.
Yes,
but अगर मैं बोल रहा हूँ कि मैं आपको job लेके देता हूँ और मुझे 8 लाख दिए, तो don't you think this is in the form of like a commission?
But sir, he was promising for giving that retired judge a job of a governor, which is not in his hands.
Okay.
So that's why I think it's
no,
the face of it. It's
आपने अगर basic आपने section 415 cheating का पढ़ोगे section, क्या बोला है? There has to be deception.
Yes, sir.
we go strictly as per the definition of law. तो 415 में आप अगर पढ़ोगे, there has to be a deception played on the party who is deceived, और उससे कुछ काम करवाना पड़ेगा जहां पे वो कोई प्रॉपर्टी आपको लाके देगा या कोई और कंसिडरेशन आपको देगा बेस्ड ऑन दैट पर्टिकुलर डिसेप्शन. तो ये तो हुआ है ना ये केस में. Are you understanding where my
yes, sir, I'm
opinion is
getting
coming
it.
from? The ingredient अगर आप पढ़ोगे, आप बाकी सब एक सेकंड, you know, in law whenever you're decoding something, एक ऑफेंस को आप ब्रेक कर रहे हो तो आपको क्या करना चाहिए, जो होलिस्टिक एस्पेक्ट है उसको जरा एक सेकंड बाजू में रखने का, डेफिनेशन पढ़ने का ऑफ द ऑफेंस अंडर द इंडियन पीनल कोड और द एनी स्पेशल एनएक्टमेंट, और वो जो डेफिनेशन में जो लिखा है वो हुआ है क्या पहले देख. इट स्टार्ट्स फ्रॉम दैट, फिर एविडेंस के ऊपर डिपेंड करेगा. तो यहाँ पे डिसेप्शन हुआ है, मिसरिप्रेजेंटेशन हुआ है, फ्रॉडुलेंट इंटेंशन था आदमी का, तो चीटिंग हो गया ना एज पर सेक्शन 415.
Yes,
Definition बैठ गया, definition बैठ गया. So of course a cognizable offense can be registered, na? Because again the reason disclosed is a cognizable offense. Abhi the legality behind he introducing an impossibility will be his defense कि ये act ही impossible था, तो ये आदमी देख कैसे सकता है. Again that will be a matter for the trial court to decide at a later stage. But offense, I think in my legal opinion, it is a cognizable offense because the definition of the offense has been fulfilled. But law is always an evolving field. Mera opinion and someone else's opinion can always differ when it comes to the interpretation of law. If you see, several high courts have given contradictory opinions, then the Supreme Court gives like a holistic opinion. So this keeps on happening in law. That is the essence of law. That is why we lawyers and anybody who's like a legal jurist or is an interested person in law always has a role to ensure that the law is evolving.
Thank you so much, Vinay. And yeah, we hope to have you for more webinars. Thank you so much.
You're welcome. You're welcome. I'm really glad to be here. Thank you to
Yeah.
you. Yeah.